Hello, my name is Mary Perham and I'm a Senior Associate in our UK Private Client team at Charles Russell Speechlys. As part of our new series, The FIC Files, on family investment companies, commonly known as FICs, today we delve into how FIC shares should be held for the next generation. I will compare outright ownership and trust ownership. I talked in the previous recording in this FIC series about the use of a trust shareholder to hold voting shares as a means of the founder retaining control as trustee. There are other benefits to a trust versus outright ownership of shares. The primary benefit is trusts can survive for 125 years and can include future unborn beneficiaries, for example, founders' descendants. For trustees of discretionary trusts, there is also a discretion as to when and to what extent they benefit the trust beneficiaries. The same does not apply for individual ownership. Whilst minors can hold shares under bare trusts, the founders cannot cater at the outset for future descendants. Once shares are issued to individuals, there's no flexibility or control over how those are held. Another benefit of a trust is that it provides asset protection for its underlying beneficiaries. Assuming it's a discretionary trust, no beneficiary has an absolute right to income or capital, and this in turn means the value is not in their estate for IHT purposes. It is also an additional layer of protection when it comes to financial threats from third parties, for example, divorce or bankruptcy. Shares owned by family members outright are theirs to do what they want with, subject to the articles. And whilst a minor's child's share would be held on a bare trust for them, as soon as they turn 18, they're entitled to be registered legal owners and to exercise any rights attaching to those shares, which some will consider too young. These shares will fall within an individual's estate for inheritance tax purposes and are open to third-party financial claims. That said, good drafting of the FIC's governing documents, for example, the articles and the shareholders agreement, can put safeguards in place. For example, they could restrict transfers only to the founder's bloodline. This is strongly recommended for the reasons mentioned. It's also worth briefly mentioning taxation of shares within the trust versus for an individual. So inheritance tax. The trust will be in what is known as the relevant property regime for inheritance tax. The shares will broadly be subject to inheritance tax at 6% every 10 years and on exits from the trust. And individual shares will instead be subject to inheritance tax on their death at 40% less any available reliefs. Income tax. So for income tax, the trust position is more complicated than outright ownership, and typically income tax is charged at the highest rate. However, there is a possibility to reclaim the higher rates of tax paid by the trustees if the beneficiaries are basic or higher rate taxpayers. So having set out the advantages of including a trust in the FIC structure, trusts are more administratively onerous than the simplicity that comes with outright shares. And as discussed elsewhere in this series, they're not for everyone. There is a fair bit of compliance with the trust, for example, accounts, tax returns, trust register, and the cost of establishing the trust. If there is a family trust already, it is a good idea to think about involving it in the FIC structure. If not, thought should be given to whether the added value outweighs the added administration. So choosing the right ownership structure for founders' families is vital for long-term family and tax planning. Trusts offer flexibility and protection, while outright ownership is straightforward but less robust. Thanks for watching, and look out for future episodes in our FIC Files series.